topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon, Chicago and Illinois. Welcome to another Ask the Expert show, where we bring you the finest, the best of the best experts in the state of Illinois. We have got a great show today. You know, when you listen to our show, we do legal, we do health, we do financial, and we do home improvement. Today, we're going to be combining legal and financial. And though both topics are sore subjects, we're going to enlighten those subjects because we are going to give you a way to do bankruptcy law, the different chapters, and when it comes to taxes and owing taxes and dealing with the IRS, we have a much better way than you dealing with them. So let me welcome our expert, Kevin Benjamin. Good afternoon, Kevin.
Good afternoon. Thanks for having me.
Buddy, let me tell you something. Kevin is one of the top attorneys in the state of Illinois. And because he handles tax relief, he can actually, if you've got a problem and you just happen to catch our show and you're in another state, he can also help you too. Kevin, since we're going through the whole state now of Illinois, we have a lot of new viewers and listeners. Tell people about your firm.
Okay, well, I'm Kevin Benjamin. I formed Benjamin Legal Services. I've been doing this since 1989, 1990, helping people get out of debt. We started doing, back in the day, we started doing consolidation. We started doing bankruptcies. There's different chapters of bankruptcies that we'll talk about in a minute. And then we started getting into the IRS tax resolution because the tax issues and bankruptcies are more similar than people realize. So the law firm is basically debt relief. We do foreclosure defense, a lot of bankruptcy, restructuring, tax resolution, stuff like that. There are different kinds of bankruptcy. Sometimes you're doing a quote unquote bankruptcy where you're getting out of debt. Oftentimes you're restructuring your debt with different kinds of chapters, stopping foreclosure, restructuring loans, stuff like that. And then obviously when people had a lot of debt, oftentimes it was tax related, IRS or state. And sometimes that could be dischargeable in bankruptcy and sometimes it's not. And when it wasn't, we had a lot of clients who needed help with the IRS resolution after we got them out of debt. And we started doing tax resolution. We've been doing that for a long time as well. And that's basically what we do.
Well, I tell you what, we're going to start off with bankruptcy first. Kevin, can you explain, there's different types of bankruptcy chapters. Can you explain the different types and the qualifications for each?
Sure. Basically, there is Chapter 7 is when someone says I'm filing bankruptcy, everyone thinks Chapter 7, getting out of debt, a fresh start, so to speak. And you got to qualify for that. They changed the laws in 2005. There's what they call an income and a means test. And there's also what kind of debt do you have, consumer or business. You could be exempt from the means test. Otherwise, there's an income depending on your state and county, which the income level is based upon your family size, and those increase every year or they change every year as well. Then if you're over the income, there are sometimes ways to get you under, to get you qualified, because there's always exceptions or exemptions or deductions you could take from the means test. So that's why you got to have a professional qualify you for that. Then you can only do it every 8 years, get a discharge every 8 years. So it's like a mulligan. If you're a golf player, you could actually, know what a mulligan is. You take your mulligan. It used to be 6 years, but now it's every 8 years, and you get out of debt. Chapter 9 is for governments when they're restructuring. Chapter 12 is for farmers when they're restructuring. Chapter 15 is like cross borders. It's very rare. Chapter 11 is like a corporation restructuring their debt. They're making payments, but they're just maybe canceling contracts, restructuring their debt, consolidating basically. A Chapter 11 can be done by an individual, but that's more of a complicated person. So most people, they have a Chapter 13 for that, which is like a corporate Chapter 11, but for a consumer, an individual, and it's simpler, more streamlined, less expensive, less complicated. Think of it like a court-ordered bill consolidation. We get your creditors off your back. You keep all your assets. 60 months max of what you could pay. Some debts you pay in full. Some debts you may pay in full or pennies on the dollar, depending on the type of debt. There's secured, unsecured, priority debt. That's what you got to have the lawyer for. There's your liquidation analysis about what you have to pay back. The means test on Chapter 13 may dictate what they think you got to pay back. So there's ways to massage those things. That's why you need a professional to go over that. But basically, a 7 is a straight bankruptcy. 13 is a consolidation. You keep all your assets. Stops foreclosure. Stops car from being repossessed. If it is repossessed, you get the car back. You could cram down sometimes a mortgage, especially if it's a non-residential. You can cram it down. If it's a residence, there's exceptions to what they call the anti-modification provision. So we got to look at that. Cars could be restructured. Other debts could be restructured. So, and basically you categorize your debts. For example, I had a phone call this morning, persons in foreclosures. We're talking Chapter 13, a lot of equity in the house behind. The bank won't take the payment. They'll take the payment, but they want all the arrears at once. So we could do it, make the current mortgage payment, make the bank take the arrears over 5 years, with no questions asked, as long as we qualify and we could show we could afford it. Then she had $7,000 in tax debt. I told her she doesn't need to have me resolve that for her. That's included in 13. So it's basically a free resolution. Couple credit cards. Then she had 2 cars that were old, high interest rates, underwater. They could be crammed down and restructured because they're more than 910 days old. There's a 910-day rule. If it's less than 910 days, you can still work on the interest rate, but you maybe can't restructure your payment. But 910 days or more, you can cram it down and do both. So you could pay back some creditors in full, some on pennies on the dollar, restructure your payments. And then she's paying, her 2 car payments were at $1,850, which is crazy. Her mortgage payment was less than that. She's paying more on the cars than she was on the mortgage, and she's behind the mortgage, but she's current on the saying. So I could restructure her and actually get relief from the $1,850 car payment. And then she could use that, pay the mortgage, and she has plenty of cash. She just didn't know it because, everyone just sees the bills and what they could do, but they don't know you could restructure and not always pay 100%. So that's basically
we hear now, there's so much talk about student loans. Can student loans be discharged in bankruptcy?
Well, the short answer is yes, but it's hard. Okay. So it's federal law bankruptcy, but it's state exemptions and there's different jurisdictions, different rules. So in student loans, like in our district, they have what they call this Brewer test, which is really like antiquated and ridiculous. And based upon this one court decision, you would hardly ever be able to discharge a student loan for hardship because it's ridiculous. So Congress has been working on that. Okay. However, over a year ago, the Department of Justice came out with some mandates to basically soften that up a little bit. So it's not automatic. So technically, no. Student loans are non-dischargeable. Okay. Once upon a time they were. Then I think it was 3 years, then 5 years it could be discharged. Then it was 7 years, I believe, and then it was none, because Congress kept changing the laws as the banking lobby, kept lobbying. And then it was they couldn't do it, but you could do private loans. Then the lobby money came for the private loans, and in 2005 they changed that as well. But there are exceptions to that. Okay, so there are ways to get a discharge. In the last year or so, it's even more interesting, is because the Department of Justice has guidelines on when not to contest the discharge or not. But I can't really answer that in like 2 minutes. So no, it's not dischargeable by law, except for the exceptions. The old case law that made it difficult, and especially in our jurisdiction, is softening up. And there's kind of a mandate right now to kind of allow it, but it's not automatic. So it's not like, I mean, people are probably seeing things online or on TV. Hey, a lot of them are legit, but some are scams. Every case is different, right? So it's possible now, and that may change after the election. So this is a political,
right, exactly.
So, but the time it's been the best time to do it the last year or so than it's been in years to discharge student loans. So you got to get a consultation.
What about married couples? Can just one of the spouses file bankruptcy?
Yeah, it's kind of like filing taxes. So you declare, like when you file taxes, you say, are you married or single? And are you filing joint or separate, right? Or head of household or whatever it is. Same thing on bankruptcy. You got to disclose, okay, I'm married. Married filing jointly, we're both filing. Married filing separate. One spouse is filing. The other spouse is the non-filing spouse. So all you got to do is declare it. So the Chapter 7 or Chapter 13 automatic stay or discharge only helps the one filing, or both if they're joint, not the non-filing spouse, but it's still household income and household budget. So let's say you're doing it, like oftentimes in a foreclosure situation, we do a Chapter 13, I don't need both spouses to file. Now I use the income and the budget to show we can afford the payments on household, including the non-filing spouse budget, but that non-filing spouse is not filing, and then only one person's filing. Sometimes they both want to do it. There's different situations. I mean, sometimes people have like a Chapter 7, they're both on all the debts they're trying to wipe out. So yeah, then you want to file a joint. You could only file a joint if you're married. You can't file a joint if you're just living with somebody, or boyfriend, girlfriend, something like that. Otherwise, it's just two cases. They just try to make it simpler for married couples. But yes, depending on your situation, sometimes you don't need both to file, and one person can't file. So if you're married and your spouse doesn't want to file, that's not a problem at all.
Kevin, people are so stressed out, and I think money has a lot to do with it. I think the most incredible thing about retaining you as their attorney is they no longer have to talk to the bill collectors. That's where you step in. And I am telling you that I have a couple friends of mine that 5-6 years ago went through the bill collectors, pounding them and the IRS. And they said once they hired an attorney, it was like the biggest burden was taken off their shoulders. And that's what you do.
Yeah, that's really what it is. There's a lot of, people got families and lives and jobs and pressures of jobs, and they're paying bills and their head's spinning. You know what I'm saying? And there's like no relief in sight. And next thing you know, the day's over and they're doing the same things like Groundhog Day. And then they hear a lot of things, or they talk to friends and hear the wrong advice, or they Google the wrong prompts. Yeah. And, they all this, the Google attorneys. Most bankruptcy lawyers like myself offer a free consultation. So, because oftentimes what you think, what a client or a prospect would think is a problem, oftentimes either is not, or it's minor, or I could explain how that could be fixed, because there's bankruptcy planning, bankruptcy exemption planning, and also timing, right? So sometimes, depending on like maybe on the IRS taxes, we'll look at it and say, hey, you can file Chapter 7. You only discharge X amount of taxes right now. This amount is not dischargeable, but if you wait, 2 months, I can discharge the whole thing. So, because sometimes, people say, I owe the IRS. Okay, that's true. Maybe it's like today's person, the example was this for 2023. But oftentimes I have people, like I have someone right now, over $1 million, over 10 different years, right? Some is chargeable, and every tax year itself is determined when it can be discharged by itself. Or if you're not doing bankruptcy and doing a tax resolution, it's called the CSED, the collection expiration date, right? Collection statute expiration date of when they could collect. So to you or a person, I owe X dollars. To a professional, you owe X dollars, but we got to break it down to what year and what is the CSED on each year and what's the possible discharge on each year, so we could help the client make an informed decision. So that's just one, one example of why you also, there's could be other reasons to file. Maybe like people call, they need a Chapter 7 again. They did one in the past. They, in their head, they say it's been over 8 years. Well, let me look. So then I could, in 5 seconds, I could look, get on the federal site, log in, and I could tell them exactly, something, you got to wait a month. It's, okay, I didn't know. So I could tell them the exact date. But then I can still get the creditors off their backs. Most of the work is done before you file the case anyway, and you start going. Otherwise, let's say they said they're eligible, but I say, actually, you got the year wrong. You're a year away, but they got to file now because they're being garnished. You can file a Chapter 13. Then in a year, in my example, when you would have qualified, depending on how things go the last year, maybe you're going to convert, And by the way, when you file a Chapter 13 and you have different kind of bills, I use the phrase, it's a court-ordered consolidation to be simple, right? But it's not a consolidation where you pay X dollar, you pay $1,000 a month, there's 10 creditors, everyone gets $100, okay? You prioritize certain debt. So oftentimes, like if they had to file 13 for 5 years, but I'm thinking maybe in a year or so they qualify for a 7, the payments made on that 13 are maybe going to priority tax debt that would not be dischargeable anyway, or something else. So the other creditors aren't really getting anything. So there's ways to do a plan. There's ways to do planning on when you're going to file. The exemptions, you got to talk to with an attorney because it's federal law, but state exemptions. It's not just filling out a form like everyone sometimes thinks. You got to know what to put on the form and what statute to put on it, how to do things.
We've gotten 4 text messages. One of them is from Addison, Illinois. I don't know if you know where that is. Great show, found it by accident. Do you do Zoom?
Yeah.
And so, what is your phone number?
Okay, phone number is 312-853-3100, 312-853-3100, or just go to benjaminlaw.com, and there'll be a different phone number on there on the website, the tracking number, but it's the same thing. So there's ways to get me through our website. You can fill out a form, and I could call you, or you could schedule an appointment through the website, or it has the information of our phone number on there as well. But 312-853-3100. We're based in the West Loop in Chicago. Most people, since the pandemic, don't come in, and I don't need anybody to come in. Sometimes there are some people that I want to see you. Okay, you can see me on Zoom, but you can see me in the office too. It's appointment only, but I'm in the West Loop. Can't just walk in because I'm scheduling my time and I have Zoom court and I have other meetings going on, stuff like that. But yes, I do Zoom all the time, and it's really convenient. And we even do Zoom courts. I'm just saying. So the federal court especially in our jurisdiction, there are sometimes they want to see you in person, more contested matters or higher end cases. But basically now it's so nice where the federal court was always actually nice, a lot nicer than the state court to go to. It's really nice the way they do it and the way they file, and the courthouse itself is convenient, and they had a very nice lobby for the lawyer, but not having to go is great too, because you could be on the Zoom waiting for your case to be called and get some work done, and you just pop on, because most of the court calls are just motions or statuses or stuff like that. But yeah, there's contested matters. But yeah, we do Zoom all the time, and that's the best way to do it. Also, document upload. Like we have an online file system. So if you were a client, you would have a portal. You would get a link to our portal, and you create your own login and password, so we could do secure communication, document upload, calendar events, stuff like that. And it's all online, all in the cloud. So there's, then I give you my direct line. You can text also, secure messages. So there's really no reason to see me. Even the online questionnaire, I give you a link. It's in the cloud. You fill out your questionnaire. I can download it. Documents, I'll give you a list of what I need. You scan them, PDF them, upload them to me, or, some people just mail them, and I'll do it for you. Some people can't scan. Yeah, there's really no reason that you got to come in at all.
Here's Bill in Champaign, Illinois. He wants to know about federal income taxes. Can those be discharged in bankruptcy?
Sometimes, yes. So the general rule is, so they can in a Chapter 7 bankruptcy, the straight bankruptcy, certain debts aren't discharged. Like they'll say federal taxes, debts incurred by fraud, child support. There's always exceptions. So the general rule is no, unless there's an exception. There's like a 5 to 7 point test of whether the taxes could be dischargeable. Basically, I would go over that with the person, and they may have just jumped on, because we're talking about that about 20 minutes ago. You may owe the IRS, and maybe in your case you owe it for 1 year, but oftentimes you have Kevin, I owe X dollars, but it's broken down for different years. So we analyze your taxes to see if each year could be discharged, and if not, when. That's part of the bankruptcy timing and filing and stuff like that. So generally speaking, no, but yes, they can be, and it depends. So the consultation will be free. There's some, sometimes someone could call, and I could just tell them real quickly on the phone if it could be or not. Other times I may need some documents, or I could pull the IRS transcript or something like that, and I could figure it out for you. No problem.
We've got actually several people. Great show. What about foreclosures? Can bankruptcy stop foreclosures?
Absolutely. As a matter of fact, the main use of Chapter 13 is people in foreclosure stopping foreclosure. That's Congress. They encourage Chapter 13s. They want you to keep your house if you can, meaning, and if you're real. They changed Law 105 to get rid of the abusers who they keep filing and they're not paying and they're just filing it. They're delaying the bank in bad faith. But otherwise, with the bank, like the person who called today is a perfect example this morning. The bank won't take they can make the mortgage payment, but the bank won't take it unless they pay them all the back stuff as well. And people don't have 10, 20, 50, 80, whatever it is, 1,000. They can make the mortgage payment, the situation's it's resolved itself, but the bank won't take it, and they try to tell you maybe they give you a month or two, maybe, and they want to take your house. So no, I push a button and it stops. Before I push the button, there's some work to do. You know what I'm saying? But I could do it in a day if I had to. I mean, so you got to file before it's sold. Now, if it's not being sold, you still got to file now. But I'm saying don't wait till it's being sold. But if it's sold first, I can't help. But if it's just started or not started yet, or even if you're in foreclosure and you get a sale of the property scheduled, I can still stop it. Okay. So what it is, you file a restructuring plan. Okay, a plan of reorganization for an individual. And in this kind of example, we would file what's called the cure and maintain plan, which is really more like a maintain and cure. Cure and maintain plan, more like a maintain and cure. So you start making your current mortgage payment a month later after I file the case, and the bank will take it because it's a federal law, right? And then you pay the arrears over 60 months, less if you want to, but 60 months max. So you make the current payment plus 1/60th of the arrearage, and the bank can't do anything as long as you're paying the correct amount and you can afford it. You can't have a budget that shows I have $1 for food or that kind of stuff. I'm saying, but basically you're saying, yeah, I can afford it. And even if you could afford to pay it sooner, you don't have to. Of course, the bank never tells you that either, right? So they say they want the money right now. So I push the button, a federal order is entered. It's called the automatic stay. They can't, all court proceedings are stayed, stopped, frozen, right? The foreclosure state court loses jurisdiction. You're now in federal jurisdiction, okay? In order to foreclose, they need permission from the federal courts. But they can't just get that. They got to file a motion notifying me, and they got to have a basis. And the basis cannot be, I want the money. You know what I'm saying? So as long as we're paying the correct amount of the arrears and the current mortgage payment, and we have a budget and we're doing it over 5 years, they can't do anything about it. And they know it, by the way. Okay. So the mortgage company would simply hire one of the foreclosure creditor mill firms, and they know how it is. They may file an objection. We say it's $20,000 in arrear. I'm making the numbers up, but it's really $20,512.07. I'm saying it's got to be the exact number, otherwise they're bound by it. Then you just change. If it's so, in my example, if we were off by that amount, then it's probably correct. We just file a new plan, objection withdrawn. Otherwise, we may object. The creditors file what's called a proof of claim. They have 70 days to file a claim of what's owed. In a mortgage foreclosure situation, that creditor, the lender, has to file the claim on the penalty of perjury with an attachment of the lost transaction, basically history report from time of default. Money in, money out. Where was the money applied to? How was the arrears calculated? Are there garbage fees in there? Are there fees in there that's not part of the mortgage? Are they not properly crediting? And I'm not saying they are. I mean, sometimes they do. You file an objection, we go to court, we argue, and the judge says, here's the number. I'm saying, if it's fraudulent, then we're filing a lawsuit against the bank, and different story. But basically, to answer this person's question, yeah, you stop the foreclosure. See, we do foreclosure defense, but you got to have a defense. A lot of people are on the line, foreclosure defense, and people, it's your house, so you don't know, you're calling, okay, let's do the. So they don't know you could just pay it. Because if the problem is you fell behind because you had a reason, but now you could pay, but they won't take it, that's what 13 is for. Boom, done. No questions asked. Because otherwise, these foreclosure defense people, they're not doing anything for you. They're charging you a little monthly low fee maybe, and they're trying to stall, but you got to have a defense. And the problem is, like I have some clients I won't take, because if they want to do a defense, first of all, I'm not doing a couple bucks a month because it's litigation. Right. So you got to have a defense. I got to find you one. So you got to look at the loans. You got to have some experts examine things. You got to find something. Okay. And I'm not saying that the person. Someone may come with an issue and it's red and white. Now maybe you're litigation. I'm saying, but most people, they don't know. They just fell behind, right? And now they're hearing, I have a new servicer. The bank. That's not a defense, okay? So by itself, right? So oftentimes, like I tell someone, well, you're paying me to then go to foreclosure court, right? And we got to argue, avoid summary judgment, have a defense, litigate the matter, okay? Meanwhile, you're paying me. So now you're out of pocket, right? Then every month I'm defending, you're farther and farther behind on the mortgage arrears. So let's say 6 months or a year later, and you're paying $2,000 a month in mortgage, you're $24,000 more in the hole plus whatever you paid me, right? And it's ridiculous if you don't have a defense, and all it is I want to save my house and pay it, but the bank won't let me. You don't have to defend. I just filed Chapter 13, which is a lot cheaper. It's immediate. It's a federal court order. It stops it. Federal court order makes them take it. So you're not, the money you're wasting on attorney fees, you could just put to the plan and resolve it. Plus, like I was saying on the beginning of this section, oftentimes, like, you have other debts that you don't know you could restructure. Like I was giving the example earlier, this person may not have been on there when this call this morning, the $1,850 on 2 car payments that I could restructure, probably reduced to less than half. So that's $1,000, right. The car payments were more than the mortgage payment. So this person could save their house. They have $7,000 IRS. They could pay that, keep the cars, you know what I'm saying, and just pay everybody and just restructure your debt. But if it's only the mortgage, that's fine too. But most people have other debts as well. And sometimes the reason they fell behind on the car payment, I was paying my credit card. Well, that was stupid, right? You're making 500, 800,000, 2,000 a month, and depending on the debt on credit cards, and you're not paying your mortgage, right? Then they say, oh, I want a loan modification. Well, good luck with that. If you think the bank is going to give you a modification because you're paying, they put your credit report, or you're paying $1,000 a month on unsecured credit cards in your current, but you want me to lower the mortgage? Now, in federal court, Illinois, like in the northern Illinois at least, and in different jurisdictions, some of them have modification programs under the federal, under the court supervision, which, like I'm doing one right now for one. But we filed the case, got the court order, right? $10,000 a month mortgage, though, is pretty high. So we got to try to apply for that because they actually need some relief to make the 13 even work. But we have the foreclosure stopped, and now we're applying and have it's a little better with the, because if it's not under federal supervision, the lenders, I didn't give me this document. Why I didn't get? We changed the fax number. That's the wrong one. They're just full of crap, and I love it where they're foreclosing, they're taking a house, they're doing this. We take over, stop them like that, right? Then we always get letters, not just me, but they send letters out to the client and to us. Hey, hello, we're the friendly bank. Here's a loss mitigation. And if you want to apply for mitigation, just call us. Oh, it's so friendly. Because in foreclosure law in Illinois, there's a Supreme Court rule. Illinois Supreme Court, to finish the foreclosure, they got to file an affidavit saying they offered loss mitigation. So now you got your little friendly letter, we offered. So like this one I'm doing right now, they were turned down originally when they called me and we filed, but I'm at 10,000 mortgage. I'm like, you probably do need something. Otherwise, we got to, that's a big nut, I'm saying. And then we got the friendly letter. So I said, okay, let's use the court mediation program because, we have to invite the lenders who partake, but I got this nice friendly letter offering us to partake, and I'm going to hold them to it. You know what I'm saying? So, yeah. And that's why you have a lawyer. There's, we do restructuring. I don't do I don't do loan mods without a court order. That's kind of, you could try it yourself, but the same crap problems the person has themselves, where the bank says they didn't get the document, blah, blah, is the same crap they're going to give us. Now, there's a pre-litigation thing I sometimes do because there's regulation X, regulation Z, without getting into all these things. That's what's called a request for information, notice of error, how to set up the bank to see if they're doing something wrong, and to also set up a defense. But that's not, that's not inexpensive, so you don't always need to do that. Now, in a 13 or an 11, if you're restructuring it, sometimes we actually throw that in because maybe we are litigating inside the bankruptcy, and we could, why the foreclosure stop, it's a lot easier to do. But if you're just wanting a loan modification without the court supervision, try it yourself. Otherwise, you're wasting your time because you want me to do it. I'm going to have to do the Reg X, Reg Z, notice of error, rest of information. No guarantee there's a problem. Have our experts examine the payment structure. So, it's not going to be just, a couple bucks. But we could do it. But it's a lot harder.
Right.
You're better off with a federal protection.
I want to get this question from a listener because we're going to move over to tax relief. It's really a good question. Hi, Kevin. Been listening to you for the last several months. I think I need to go into bankruptcy. Do you consult your clients if they should go into bankruptcy? What kind of bankruptcy? Or should they tough it out? That's a good question.
Well, first of all, I don't know what tough it out means. That's ridiculous. You call me, the consultation's free. Okay. And what I do is exactly what this question was asked. What most lawyers should be doing, not, and most of them do, but they're the ones that don't. You call me, I analyze your case for whatever your option or options are. Bankruptcy, non-bankruptcy, different kinds of bankruptcy, timing mechanisms, and then what are the pros and cons of each, what does each cost, and help you make an informed decision, and also talk about timing, okay? We get organized. And I could do that on a one Zoom or one phone call. I can get, if you give me some information. I have people call,
Right.
I need help. Okay, how much you owe? I don't know. No one knows anything. So,
Right.
I'll tell you what you need to know. I'll tell you what documents I need.
I think he wants to know if you analyze it and give him different options.
That's exactly what we do. We analyze it for you, okay? Because you're not a lawyer. How would you know, right? So you give me the financials. I don't know what her case is, if it's a foreclosure or someone's garnishing or whatever. So a car issue, tax issue, whatever it is, we'll analyze your case for all kinds of chapters, or maybe even non-BK if you don't need it. Otherwise, what option or options, what kind of cases do you qualify for? And help you make an informed decision. Sometimes you could do a combination, which there really is no such thing. But like a 7's basically getting on debt. There's exceptions to discharge. 13's a consolidation. But sometimes you could pay some bills in full and some bills nothing, get discharged, or pennies on the dollar. So it's like doing a full 7 on some debts or partial 7 on some debts. So there's no such thing as doing both, but there is. It's still a Chapter 13. It's just a plan that pays certain creditors less than 100%. So in a Chapter 13, you pay some bills in full, sometimes all of them, but sometimes only certain bills in full, and other bills less than in full, pennies on the dollar, or sometimes even zero. If you got a mortgage issue, foreclosure, the arrears that you're behind, the payments you missed, late fees and attorney fees, that's paid back at 0% interest. Your mortgage payments that you start making would be the contractual number, which includes interest, probably taxes and insurance. But the part you're behind is 0% interest. The credit cards are 0% interest.
Let's give everybody your phone number and your website before we go into
Kevin
the IRS
relief. Sure. Kevin Benjamin Legal Services, 312-853-3100, 312-853-3100, or go to benjaminlaw.com. Our phone numbers, and on the website, you could actually just give me your name and email, and we'll call you, or you can schedule an appointment. But all the information is at benjaminlaw.com. We also do the tax resolution. It's on the benjaminlaw.com site, but we also have a separate company also called Noble Tax Relief, nobletaxrelief.com, which is only tax resolution. Doesn't really matter which one you go to for the tax, because it's still me. I'm still the one going to be doing it. But Noble Tax is not a lot. Noble Tax is just the tax stuff. Benjamin Law does both. But whatever site you're going through, you still get me.
Good. Let's go into tax relief. I hear more about this Fresh Start initiative. Can you explain that?
Yes, I can. First of all, what you're hearing is basically the people on the radio.
Yes.
People talking about the national companies doing tax resolution. There's a Fresh Start initiative, and the IRS is going to forgive all your debts. That's not going to happen. What it is actually the initiative started in 2011. That's when it started. So it's been around forever. And all it did
is not new.
Yeah. So there's different ways to do things. So there's different programs for tax resolution. IRS offer and compromise, installment agreements, currently non-collectible, penalty abatement. And then of those each, there's stuff there's different kinds of offer and compromise, doubters to liability, doubters to collectability, or effective tax administration, meaning, in fairness, we should be able to do this. Installment agreement, full pay or partial pay, time lengths, right? Currently non-collectible is getting a freeze on the IRS where they're kind of back off. So the Fresh Start initiative in 2011 actually helped, because what it did was the IRS changed like their offer and compromise stuff. Like it's a cash flow. It's an exercise in cash flows. Okay. So what they do, it used to be like looking at how much disposable income, which is negotiable in different formulas that you're looking at over 48 or 60 months. Now it's 12 or 24 months. So there's more people qualify for an offer and compromise. Okay. For an installment agreement, they started the partial pay installments. So you're paying less than, a full installment agreement. So for example, there's different thresholds also, a streamlined installment agreement or non-streamlined. So it used to be like up to 25,000. Streamlined meaning like, no documents needed, just get it done, right? With the Fresh Start, now it's $50,000. If you're self-employed and it's not income tax, but it's the payroll tax you had a problem on that you didn't pay, that you took, then it's $25,000, which they didn't have, before. Also, the Fresh Start initiative on getting liens. Like it used to be, if you owe $5,000 or more, they could put a lien on you. Now it's $10,000 since 2011, right? Also, getting a lien released or a levy stopped or stopped. They made it better for the person. So the Fresh Start initiative was ways to help get you, more people qualify for offer and compromise and stuff. But not everyone qualifies. I mean, there's not really an income limit, but like, you're talking about $50,000 or less for the Fresh Start. That's just for a streamline, though. I'm saying. So the Fresh Start initiative, does it exist? Yes. Is it new? No. So you got to be careful on the airways when people are call me now. IRS, this came out yesterday. You don't got to pay your taxes anymore, and you're going to be forgiven. That's just a con job. It's been around for forever, and all it is basically is tax resolution. They made better streamlined amounts for you, better, higher thresholds before they could lien you. So it's better for you, but it's nothing like that's going to really help you, because if you owe like a lot of money still, you may not qualify for the streamline, which is fine. It doesn't make a difference. I'm saying that's why you have a tax professional. So let's get it done, right? So, people don't know. Everyone calls for offer and compromise. Not everyone qualifies, right? And there's different kinds of offer and compromises too. So we take the same approach.
Very misleading.
Yeah, we take the same approach to the tax as we do with the bankruptcy. We analyze you for all possible resolutions, offer and compromise, which kind, installment agreements, which kind, and see what you qualify for, because you may qualify for more than one. And then as your professional, we decide together, hey, something? Which one should we go with? Because I have to give you a recommendation that says, hey, I don't know, you may qualify for both, but even if you have an offer and compromise you qualify for, the government looks at both as well, right? So the government says you owe $100,000, you're doing an offer for $10,000, but you can do an installment agreement for $40,000, right? Well, 40 is 4 times 10. They may say, no, you don't qualify because you can pay me back 40, right? On the other hand, sometimes you could have a lower offer and compromise figure and a higher installment agreement figure, depending on how the discrepancy and your situation on collectability, where they may say, well, we may get more in an installment agreement, but not enough to risk losing the offer deal, because maybe the person is elderly or very old. Maybe they won't be paying the whole time. There's other effects, or maybe it's the amount that's not so much great, where if you wait, 72 months on an installment agreement, for example, and things could happen. Maybe they stop paying, right? Where a bird in the hand, getting the offering compromise is better. But it's only if it's a certain amount better. Otherwise, they will wait the time. But that's why we'll analyze that for you and give you our opinion. Plus, as you move along, things change. Some people are self-employed or not. Sometimes a change. We can renegotiate things. What assets are exempt, or valuations on what can be liquidated if on the formula. Not that you're selling anything, but the IRS looks at what could I collect. It's an exercise in cash flows. How much you're making, what are your assets, what are your expenses. Now, with that said, you can't have like, oh, I live alone, I spend $2,000 a month on food. Then on the formula, they're not giving you that. You know what I'm saying? So there's IRS standards. So in a bankruptcy, they have IRS standards for the means test. And in tax resolution, there's IRS standards for tax resolution. Those numbers actually differ a little bit. But the point is, there's a formula on an amount they give you as we determine your cash flow, whether it's a bankruptcy means test or a IRS resolution on cash flow, right? Then it's a negotiation. The IRS says this is the number. We say this is the number. They say it's worth this. We say it's worth that. I'm saying, can an asset really be liquidated? Or is it really worth anything? Should it really be included? And that's where we have the tax professional to not just plug numbers in, but to support it and be able to do things. Plus,
exactly.
Also, it depends on, are you in the automatic collection system, ACS, or do you have a revenue officer or agent assigned, right? How much do you owe? Are you self-employed? Are there other assets? So it depends where you are. Then you got to say, what about, just because the IRS says no doesn't mean it's no. It's the same thing as being a lawyer, right? It's called an appeal. You know what I'm saying? So there's different kinds of appeals and different deadlines. And there's also other appeals after that, if it came to it. Not everyone needs that, for the U.S. tax court. And I've been a member of the U.S. tax court since like 1990, right? So not everyone has to go there, but even you got to be an attorney to be in the tax court. There is an exception sometimes where a CPA or an EA could get admitted, but they have to do a lot of stuff to do it. So with us, or through me, I mean, basically, bankruptcy or tax resolution, it's a cash flow analysis, liquidation analysis, IRS standards negotiation, analyzing collection statute expiration date on a tax resolution for each tax year. When does it expire? Because they only got 10 years to collect. If we're doing something, that's part of the negotiation on a partial pay installment agreement or a regular installment agreement. How much can they get before the expiration of a deadline? That's part of the formula too. So I have people that call me up. Hey, they did their own installment agreement. They didn't know partial pay. They didn't know this. They didn't even know offer and compromise because the IRS didn't tell me. I was on their website. Well, they're not your friend, right? That's why you hire someone out and say, you're saving some legal fees, but you're paying back $100,000 more than you had to, or something, or you can't even do it.
Hey, Kevin, we've only got a minute left. Give everybody your phone number and your website again.
Kevin Benjamin, 312-853-3100. You can find me at benjaminlaw.com or nobletaxrelief.com. Either one will get me. Check out the web pages. You could ask for help on the web page and give me your name and email and phone number, and we'll contact you, or you could set up an appointment. No problem.
Beautiful. Hey, and Kevin will be back with us again next month with more Ask the Experts. Thanks, Kevin. Great job.
Thank you. Take care. Bye-bye.
That's attorney Kevin Benjamin. That'll do it for us today. Join us again next week for more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.